even though it was more neutral in the classroom, very educational, very easy to understand. And so I thought out of everybody that I, respect, especially in the common law field, Professor Blackman is definitely that person. He's written 3 books, and so they're unprecedented, Unraveled, and an introduction to constitutional law, which is Supreme Court cases everyone should know. So that sounds like a great stocking stuffer.
So buy a copy. It is a very well-selling book.
Awesome. I didn't even know it was out, and it actually came out in 2019, and so I was thinking I need to pick that up since I honestly have never been very good at common law. So that's definitely one that I was thinking about getting. But he was also published in Forbes magazine for 30 Under 30 in Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar in the Cato Institute. He's the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, which is really interesting. It's the internet's premier Supreme Court fantasy league. And he has blogs on joshblackman.com, where you can find all this information. And he's the author of nearly 5 dozen law review articles, and his commentary appears in the New York Times, Wall Street Journal, Washington Post, USA Today, and so forth. So I'm really pleased that we got this person, Professor Blackman, to come in and talk to us, especially on this small scale level, about something that I've had a million questions about. So I cannot wait to ask them if he does not cover them first. So
thank you.
I will turn it over.
Thank you, Christiana. It's always good to see my students in the wild, so to speak. After they graduate, I never see them again. But it's always good when I see them, they come back, and they invite me to speak. And I'm always happy to do so. The topic today is the future of the Roberts Court. And we are really at a critical juncture where things are changing pretty quickly. Throughout much of the 1990s and early 2000s, the court remained exactly the same. Justice Breyer was most junior justice from 1994 until 2005. So for 11 years, the court stayed exactly the same, and it became a very stable institution. Since Chief Justice Rehnquist has passed in 2005, not 15 years ago, we've had significant turnover. We now have Chief Justice Roberts. We have Justice Alito. We have Justice Sotomayor. We have Justice Kagan. We have Justice Gorsuch. We have Justice Kavanaugh. And we have Justice Barrett. We have 7 new members of the court in 15 years, which, just if you pause, is a pretty quick turnover by modern standards. And the past couple of years have been extremely, I think, chaotic for the court. In this past year alone, we had a presidential impeachment, which no one remembers at this point, in which Chief Justice Roberts presided. We had an epidemic shut down the court, in which they've transitioned to all telephonic arguments, which is stunning if you think about the Supreme Court. And throughout this entire time, the middle of the court keeps moving to the right. For the longest time, Justice Kennedy was the center of the court. And then upon his retirement, the center moved to Chief Justice Roberts. And for about a year or two, the chief was in the majority in almost every case. He was the median voter. And then with Justice Ginsburg's passing and the confirmation of Justice Barrett, the median, the center, moved even further to the right. And it's now probably with Justice Gorsuch or Justice Kavanaugh in any given case. So now, for the first time, really, in a lifetime, you have what's more or less a 6-3 conservative court. And we have this court now with a new administration coming into town that's Democratic. And I think we're going to see a lot of these tensions form. So what I'd like to do is give you a brief overview of the term that happened last year, that just finished, and talk for a bit about the term that's coming up now that we're about 2 months into. And maybe if you want, we talk about the election for a bit, but I think that's that litigation will be over any minute now, I think. The October of 2019 term was the first full term for Justice Kavanaugh. He had been confirmed the year before, but because of his additional hearing, his start date was a little bit delayed. So this was the first term that Kavanaugh was in from the beginning. And the first major case the court heard, is one that I'm sure is of much interest to this group in particular, was Bostock, right? This was a case that considered whether Title VII, the Civil Rights Act of 1964, prohibited discrimination on the basis of gender identity and sexual orientation. And this was a case argued back in October. The case turned out perhaps not how everyone would have expected, but as a 6-3 decision. Justice Gorsuch wrote the majority opinion, and he was joined by the Chief Justice as well. There was a very bitter and vigorous fight on the court among the conservatives about what is textualism. And to be frank, I was not a fan of Gorsuch's opinion. I criticized it heavily for reasons I can discuss maybe later. But I think what this decision shows is that justices are not always easy to pigeonhole. And in any given case, I think most members of the court can surprise. So I think it might be a little bit short-sighted to simply say, oh, it's a 6-3 conservative court. That means without question there will be only conservative rulings. And I think as a person who tends to be in the right of center, that's unlikely to happen. Justices tend to vote in unique ways that are somewhat unpredictable. The next major case the court had last term concerned DACA, the Deferred Action Program for Childhood Arrivals. This is this executive action that began in 2012, so we're now on year 8. And it granted what's called lawful status to certain young immigrants. And this policy also had the effect of deferring their deportations. This has been going on for nearly 8 years. The Trump administration tried to undo the policy. Almost immediately, he was sued across the country, challenging the decision to cancel DACA. Once again, the court ruled against the conservative side. Here, you have Chief Justice Roberts writing the majority opinion. Roberts found that the decision to rescind DACA was within the president's discretion. But, and here comes the big but, the president did not provide a good enough justification to wind down the policy. Specifically, the president hadn't considered what are called reliant interests. The fact is that a lot of people have structured their lives around this executive action, and the decision to cancel it didn't take full account of those people. Now, what does that mean going forward for DACA? This is actually a huge question mark, because the court didn't actually say whether DACA was legal or illegal. The court punted on that question entirely. The lingering issue is, how will President Biden undo President Trump's undo? What? Ready? So President Obama created it. President Trump tried to undo the Obama policy. So now President Biden will have to undo the President Trump's undo, right? We're in this sort of this Russian nesting doll of Administrative Procedure Act where everything just sort of stacks onto each other. It's a very messy case. I don't pretend to know how this one's going to come out. Keep in mind one other factor. Chief Justice Roberts was the decisive fifth vote, and he wrote an opinion that refused to opine on the legality of DACA. I think now there are 5 votes say DACA is illegal, right? Which doesn't mean people necessarily lose their status, but it means that you don't grant new renewals. There's actually a case pending right here in the Southern District of Texas, brought by the Texas Attorney General. He's been busy recently, right? Challenging the decision to keep DACA on the books. Now, that case was put on ice during the Trump administration. I think that will become much more relevant going forward. So the DACA case is messy, and that's not going anywhere. The next major case from last term was an almost nothing burger, right? It involved the Second Amendment. And Christiana was one of my students. I know we learned about this in school, but it doesn't really mean anything, right? And there are two major Supreme Court cases where the Supreme Court said there's a Second Amendment right, and that for nearly a decade, the court has not touched a gun case. Finally, the court took one from New York. This was a very strange law. New York said that if you want to carry a gun from one house to another, let's say you have two homes, you need to get the special license, which is pretty much impossible to get. If you want to go to a shooting range, you can only go to a shooting range in New York City. You can't go to a shooting range in New Jersey, for example. You can't go to a target practice range in Pennsylvania. It was a very bizarre law that I think was almost irrational, that you couldn't transport a gun from one house to another. And this is, by the way, not open carry, concealed carry. This means a gun locked in a container in your trunk. Right? This is a very bizarre law. New York was happy to defend the law in the lower courts, but the second the Supreme Court granted cert, what did the government do? They repealed the ordinance, and the state enacted another law making it impossible to reenact the ordinance. Now, you may not like guns or the Second Amendment, but from a point of civil rights litigation, this is really bad, right? Where the government goes out of its way to repeal a statute for the sole purpose of evading judicial review, right? And there are different doctrines to handle this, right? There's capable of repetition, yet evading review. There's voluntary cessation. But here in New York, I think made it airtight. The statute was not coming back. What happened? A majority of the court dismissed the case as moot, which I think was the right result. It's very bad practice, but they were right to toss the case. But then you had three justices dissent saying, well, we should have kept it. And then a fourth justice said, well, we don't need this case, we'll take another case. So it seemed that maybe the court will take another Second Amendment case down the road, right? What happened? There were 10 Second Amendment cases in the docket, 10. Everything from concealed carry to assault weapons to felon disenfranchisement. There were many gun cases in the docket. All 10 were denied. Why? If you believe the reports, Chief Justice Roberts decided he didn't want to take a gun case. And the other justices were too afraid to take a gun case if Roberts was not in the majority. Well, guess what, Johnny boy? You're not the fifth vote anymore. So I think we'll get a gun case soon, very soon. Justice Barrett was quite strong in the Second Amendment and has written several dissents on that point during her brief tenure as a circuit judge. So I think we'll see strong changes in the Second Amendment jurisprudence. The next major round of cases from last year concerned President Trump's tax returns, which, by the way, we are now December 8th. We still haven't seen them. It's like this is like the song that never ends. It's like, oh, the tax returns, right? Just they exist somewhere, but we'll never ever see them. There were two cases. One was brought by the New York District Attorney in Manhattan. The second was brought by several House committees. The court split the difference. They said the House could not see the tax returns, but the New York District Attorney could see the tax returns, which is almost the opposite of what I thought would happen. But the New York proceeding is before a grand jury. Those proceedings are thankfully confidential. We don't want to know what's in them. That's a good thing to have confidentiality for grand jury proceedings. And as far as I know, there's still litigation going on over whether the tax return should be turned over. This is going to petter out after January 20th. No one's going to care anymore. Or maybe they will. I don't know. Who knows? What do I know? But this seems to just be dragging out indefinitely. The court didn't give a clear resolution, so now there's more litigation of whether there's actually a need for the tax returns, etc. Okay. The next major case from last term concerned the Little Sisters of the Poor. This is another song that never ends. It involves the Obamacare contraceptive mandate. I have 2 books on Obamacare. You're welcome to buy copies of them. I'll be happy to virtually sign them if you want. The latest case was that the Trump administration tried to undo the Obama administration's contraceptive mandate, and they claimed it violated religious freedom. Once again, the Supreme Court did not rule on whether the contraceptive mandate violates religious freedom. Instead, they ruled on very narrow procedural grounds, saying, well, the president can rescind it, but remand to go think about other things. Again, the chief was in the majority. So the Little Sisters go back to the lower courts and have to fight even more so. But now the next battle is, can the next administration undo the Trump administration's undo of the Obama administration? It's the same pattern, right? where Obama made a policy, Trump tried to get rid of it, and now Biden will have to get rid of Trump's getting rid of the Obama policy. It sounds easy, but it's not. The APA is hell. It's like Dante's Inferno. You just never escape. There's always another ring. You keep going deeper and deeper and deeper into this internal purgatory of administrative law. This is why I don't like teaching admin law. It's painful. It never ends. There's always comment. There's always review. There's always remand. It's just this never-ending saga. So the sisters keep litigating. All right. Next, we get to June and the very end of June, right? Usually the Supreme Court wraps up its term by the end of June, but because of COVID, they spilled over into July. One of the big cases during this sort of overtime window involved funding for religious programming in schools. The case is called Espinoza versus Montana Department of Revenue. Montana had what's called a no aid provision, which might be called the Blaine Amendment, although that name's kind of loaded. Under state law, the state could not provide any subsidy for for religious education. The court more or less held that this provision is unconstitutional. They didn't quite say so. It's a very messy case, but they said that the government cannot single out religion for disfavored treatment. As a result, the state cannot deny these sort of tax credits for religious schools. Okay. Finally, we get to the end of the term. Okay? Not really. Because throughout this entire time, we have more litigation over COVID. Yes, the Supreme Court was asked to review several cases in challenging lockdown orders. The first and most significant case was called South Bay Pentecostal Church versus Newsom. It was a case from San Francisco. The court denied an injunction which allowed the governor of California's order to remain in place. And the Chief Justice wrote what would be a very influential concurring opinion where he said, the Supreme Court should not get involved early, and we should not be granting injunctions when the situation is very fluid. I think people completely misread him. This was not for lower courts to adopt. It was a Supreme Court decision by one justice. Later in the summer, the court decided a case called Calvary Chapel Church versus Sisolak, which was a challenge from Nevada. In Nevada, Caesar's Palace could open up without hard cap restrictions. You could fit thousands of people in Caesar's Palace. But if you have these huge mega churches, they were capped at a very small number of people. Again, the courts put 5-4. Roberts did not write separately, but the dissenters said you can't treat religion in this sort of disfavored fashion. Just last week, we have another case from New York. And for full disclosure, I did an amicus brief in this case. I'm also representing a Jewish school in New York. So I have a dog in this fight. But New York put these very strict limits on houses of worship. So you might have a temple that fits 1,000 people, but they limit it to 10 people, right? I mean, if you have a venue that fits 1,000 people, you can have more than 10 people. I think we would all, say that you can do it safely. The Supreme Court ruled on a 5-4 basis that this order was unconstitutional. Chief Justice Roberts dissented, and he basically said, well, the governor of New York changed the policy at the last minute, so I wouldn't decide this case. See, again, New York, when they were afraid of losing, they replaced their laws. That's what they do. They revise their policies to evade review. That's a very common tactic. Okay. Now let's go to the current term. The current term, the biggest case so far involved the Affordable Care Act, which I've written many, too many books about. I've tried another one now. This case is a challenge. Oh boy. This case is a challenge to the ACA. You might say, wait a minute, Josh, didn't the court already uphold Obamacare? Well, just wait. In 2017, Congress reduced the ACA's penalty to $0. And the argument went, this law that reduced the penalty rendered the Obamacare law unconstitutional. Right? The Chief Justice upheld the ACA as imposing a tax, and now it doesn't resemble a tax. I can go into the details later if you want. The long and short of it is the court will not kill off Obamacare. The law is safe for another day. Beyond that, I'm not really sure, but the law will be safe. Another big case, which is probably also some interest to this group, is called Fulton versus City of Philadelphia. The City of Philadelphia, and actually the facts here are messy, but the Catholic Charity Services of Philadelphia has been providing foster care services for over 200 years. It's a very well-established group. they will not refer, or they will not, I want to get this right, they will not work with a same-sex couple with respect to the placement of children. The actual process is very intricate, but I can just say they will not work with a gay couple for the placement of children. And the church brought a lawsuit saying that the city's policy, the city's non-discrimination policy, violates the religious exercise. This case, the church is probably going to win, but on which grounds, I am not sure. I don't think we'll get a sweeping ruling on the First Amendment. I think the court may actually sort of punt and simply say it's not clear that the Catholic Charities is actually being denied the ability to work with the city given this policy. It's a very messy policy. The court might even remand for further proceedings. The reason why is that these foster agencies don't, how do I put this? The Catholic Charities does not have the monopoly on this process. There are a lot of groups that perform this service. So there might be some way the court to sort of just duck the issue. I don't think they're going to take it. I think the facts are just too messy to have a sweeping First Amendment ruling. It's a really complicated case. There are a lot of other cases that present this sort of free exercise issue a lot more neatly. Other litigation that's ongoing now concerns the election. Today is December 8th. Happy December 8th, everyone. You may not know this, but today is a very important day for the calendar. December 14th, the Electoral College meets. Yes, next week. It's in 6 days. December 8th, today, is what's called the Safe Harbor date. Josh, what's a Safe Harbor date? Under the Electoral Count Act, our very favorite statute, the states are required to submit their certifications by a certain date. Okay? If they submit their certifications by today, by December 8th, the Congress will presumptively treat it as accurate. If a state submits a certification after today, in theory, Congress is more able to challenge it. The idea is if you have this ongoing recount, right, in a state and things are uncertain, maybe then Congress should take a closer look. Very famously, 20 years ago, when we were all quite young or younger, in Bush v. Gore, the Supreme Court had to hustle to issue its decision on a certain date because of the safe harbor date, right? The Supreme Court ruled on the safe harbor date to ensure that the votes were certified in time. Why does that matter? All the pending cases before the Supreme Court involving the election basically become irrelevant after tomorrow or any minute now. I haven't checked Twitter recently, but maybe we'll get another decision any minute now. Let me just reload, see if anything is new. No, there was a decision earlier involving a Pennsylvania congressional race, which wasn't very important, but all the Trump related cases I think become moot in a couple hours. Like in Cinderella when the clock strikes 12, I'm not going to make a pumpkin joke too easy, but too easy. But yeah, when the clock strikes 12, everyone turns into a pumpkin, and then we're just, aren't you glad you invited me? There it is. They're lefters on Zoom, I see. All right, that is, I think, the biggest issue so far. Now, what's on the horizon? I think we have shifts in a couple areas of the law, one of which is abortion. Without question, the court is moving on abortion to the right, no question. And that was before Justice Barrett's confirmation. Last term, the court decided a case called June Medical. The Save Louisiana, our friends to the east, our friends to the east enacted a law that very much resembled the Texas law, where abortion doctors had to gain admitting privileges to nearby hospitals. And you might say, Josh, wait a minute, didn't the Supreme Court already rule those laws unconstitutional? Yeah, they did. But Louisiana did something very similar. It wasn't identical, but it was pretty similar. 5-4 court ruled that the Louisiana law has to be set aside. But Chief Justice Roberts said, well, I'm going to declare this law unconstitutional, but the next one will be fine, right? I'm just doing this because of stare decisis. I actually don't agree with this precedent. So Roberts signaled that the court's abortion jurisprudence is in flux. And that was before Justice Barrett came along. I don't know that there are any abortion cases in the docket this year. You might want to wait a year or two, but that's an area where I think we're going to see a move. The next area that I think we're going to see some sort of shift is affirmative action. You may remember there was a case involving, why is it always Texas? UT Austin, right? Abby Fisher from Sugar Land, not too far from here. She challenged the UT Austin's admission policy. This was with Justice Kennedy casting the deciding vote. The court ruled that the UT policy was valid. That was actually a 4-3 decision. 4-3? How's it 4-3? Well, Justice Scalia died and Justice Kagan recused. Is a 4-3 vote precedential? Ain't 5. You got to count to 5. 4 ain't enough. So I don't think we actually have a precedent. I flagged this in my casebook 4 years ago. I've been waiting, but I think Fisher's going to be overruled. There's cases pending at Harvard, brought by a number of Asian students, and there's cases pending at UNC in Chapel Hill. And there's still other cases involving UT. They just never go away. So I think in the next 2 years, maybe a year, 2 years, not sure exactly when, the court's going to scale back the affirmative action jurisprudence. Those are the two areas where I think we'll see the biggest shift, abortion and affirmative action. Of course, the variable is with the Biden administration. President Trump was basically saddled with all these Obama-era policies. You just couldn't get rid of them. I think we're going to see a repeat. I think President Biden will be stuck with all these Trump policies he can't get rid of. It's just this interminable APA, the Dante's Inferno. You keep putting more and more rings of arbitrary and capricious review. It's just hell. But I think for a large part, the Biden administration will be saddled with the vestiges of the Trump administration in the same way that the Trump administration was saddled with the vestiges of the Obama administration. Just we're always 4 years behind reality. Or then again, maybe the court will say this is insane and a new president comes to town and make his own policy, which I would favor. I don't like this idea that you're always bound by what happened before and you have to jump through a million hoops to undo what happened in the past. Okay. All right. I've been going about 30 minutes. I'm going to stop here. We have a lot of, time for Q&A. I'm happy to chat further. So thank you all so much.
Thank you. I do have a question, actually. I've been hearing a lot of, and I'm very ignorant on this topic,
No, you're not. Stop it. You're my student. You are absolutely not. Stop it. Stop it. Stop it. Stop it.
I don't understand when people talk about packing the court. I've heard this jumping around a lot. And so they're talking about, I don't know if the Biden administration would pack the court. What does that mean? Can they add justices?
Sure.
Is that even constitutional?
If you are my student and you're a graduate of South Texas, you are absolutely not ignorant. Be proud. Represent South Texas. No, she's a good student, by the way. I'm not just making a very good student. So court packing, right? What does court packing mean? Depends who you ask. It's a phrase that I thought had a settled meaning, but maybe doesn't want to have one anymore. The Supreme Court has been at 9 members since the 1860s, right? We've had 9 members. That number is not set by the Constitution. That number is set by statute. And throughout history, Congress has modified the number of justices. But again, the number 9 has been set since the 1860s, so it's pretty settled. During the 1930s, President Roosevelt famously proposed expanding the Supreme Court. His idea was, well, the justices are too old, they're working too hard. Maybe we'll add, for all the justices over 70, give me one new justice. It was just a way to put more progressives on the court. That was his plan, and that plan backfired, and his own party opposed him. Before the election, many progressives said, well, the only way to undo this 6-3 conservative majority is to add 2 or 3 more liberal justices. And that talk died down very quickly after the election because it became clear there were no votes for it, right? You can't count your Supreme Court chickens before they hatch, right? If you had 58 votes in the Senate, I think you could have pulled it off, but not with a 52 or 50 vote majority. Simply, it's not possible. So I think for the foreseeable future, court expansion is off the table, thankfully. I think it'll be a disaster. Once you add 2, you add 4, you add 6, you're never going to end it. But I fully expected if the Democrats had enough votes, they would try it. I think now that's off the table for at least a couple of years. Okay, other questions?
Well, good afternoon, Professor Blackman. John Lohman here, South Texas graduate 2013, so I'm only like 7 years into this.
Oh, great.
Yeah, it's like a career, as you can tell. So
I started teaching in 2012, so I would have missed you, unfortunately.
Yeah, actually, I do remember your name. Yeah, if you were there, I just did any of your classes in my last year. So anyway, thank you so much for doing this for us. I really do appreciate it. It's very, very informative. Getting back to Bostock, just one quick question for you. Tell me if Bostock is now the land of the law that people cannot
Okay.
Okay, I think the last part of your question broke up. I think it was asking what.
Walk on over there.
I think the question was Bostock.
I went ahead and muted Brett because he was getting a little feedback, I think.
Yeah, Johnny, can you repeat your question? I was hearing some feedback, please.
Yeah, sure. Yeah, I hear a little feedback on myself. I'm sorry. On Bostock, is basically now the law of the land. Someone cannot.
Tuesday, the 15th or 14th.
Hold on. I think Lance has his microphone on as well.
Yeah, I just muted him.
Okay, you're like the kingmaker. You're like off with his head. All right, go ahead.
I'm just curious, is Bostock now the law of the land that protects gay and lesbians and transgendered and everyone else from being fired strictly on the basis of gender identity or sexual orientation? And thank you.
Yeah, thank you. I think the answer to the question is yes. I think there was a lot of grousing among conservatives on the textualism, the actual legal analysis in Bostock. But I've seen no resistance to the case. In other words, in every circuit, even this circuit, the circuit judges have applied it faithfully. And I don't think there's been any attempt to evade the ruling. So even in the absence of, the Equality Act, some other legislation, I think Title VII has now been uniformly applied in every circuit with respect to gender identity and sexual orientation. There's just been very little resistance. It's one of those things like this wasn't done yet, right? It's almost strange, if I can just indulge for a minute, that you have a decision on same-sex marriage 5 years before you have a decision on discrimination. It almost seems backwards, right? Wouldn't it be first you have something like a statutory protection for civil rights that you can't be fired or you can't terminate someone from a job, and then you get to marriage, right? It's almost because before Bostock, the state couldn't deny you a marriage license, but the second they gave them, they could fire you, right? That was actually the lay of the land, which whatever you think, it just seems backwards. But that's how the litigation arose. But I think at this point, Bostock's pretty settled. People are unhappy about the legal analysis, but there's no, in theory, I suppose Congress could pass a statute to rescind Bostock. I think there's a 0% chance of that happening.
Thank you very much.
My pleasure. I like South Texas people. Very good to hear it. What other questions you have?
I have a question.
Sure.
I am doing 100%, mostly 100% immigration law these days, and it's been an interesting roller coaster the last several years. And to your point about administrative law, there's been a whole plethora of different types of administrative decisions that are going to be, I would imagine, would be years from overturning. But my question is coming back to DACA. I just spent the day doing appointments with clients without signing them up, but basically pre-qualifying them for DACA, for new DACA folks, because there was the federal judge that forced the Trump administration to reopen it. So I'm trying to determine what your message is regarding the current pending legislation in terms of DACA, or in terms of the court case, and the way it relates to what the Biden administration might do regarding DACA.
I don't know. Has the Trump administration sought a stay yet of that ruling? Do you know the answer?
Has it stayed?
Have they sought a stay? There was a judge in Brooklyn, in the Eastern District of New York. Do you know if there's been a stay that was requested?
Yeah, there was, and then just this last weekend they reopened it again and forced the Trump administration to begin accepting the Immigration Service to begin accepting new DACA applications.
Well, look, you might get a Supreme Court stay application any day now. So, I mean, as an attorney, you should definitely submit paperwork when you can. I mean, it sort of sucks that you never know if it'll be approved. I don't think the court can make the government grant the application. They just have to accept the paperwork. I think that's sort of the weird catch-22 your clients would be in. The Supreme Court, now this is my own professional opinion, I think there's a good chance the court simply says the Trump couldn't undo it, but you can't force him to accept new ones, right? I think that's a very strong possibility. So the Supreme Court may intervene in the next couple of weeks before the election and simply say this ruling is not permissible. So in other words, if you have it, you get to keep it, and they can't take it away from you, but the government's not required to grant new licenses, which is, again, not very reassuring for your clients, but I think that's a distinct possibility. This is what I mean by Biden is trying to undo the Trump policy, right? So in other words, Biden can't just, do not pass, go directly to jail, right? He has to go through each step of the process, and he can't just say, okay, I want to do what Obama did, right? He has to sort of think of like, you have a garden with weeds, right? And you want to get to the soil, but you have to pluck out all the weeds. And if you miss all the weeds and you don't get to the soil, it's like this garden where you have to just fight through these weeds to get to where you actually want to go. You can't get back to the actual soil. But good question. Thank you. Other question?
So you see that there's going to be continued.
Oh yeah, and don't lose sight of the fact that Texas has a lawsuit pending. It's ostensibly in Brownsville, but the judge is now in Houston. Judge Hainan. I think he sits almost in Houston now exclusively. But I think you're going to have more litigation on that one. My pleasure.
Thanks for doing this, by the way.
It's fun. I enjoy doing this. I don't have classes now. This is a good respite from grading, so I'm happy to do it.
I have a question back to Amy Coney Barrett, Justice Barrett, and the what you referred to as the likelihood that the court is going to move further to the right on abortion. This is why I was bad at common law. I'm like, what does that mean? What exactly does that mean? What is going to happen? You know what I mean? I don't know how to, what do you forecast realistically actually happening in that move to the right? I'm just out of sheer curiosity.
A few things that I see possible. I mentioned abortion. I mentioned affirmative action. I mentioned guns and Second Amendment. I think those are probably the areas where you're probably going to see conservatives winning more cases than they won in the past. Because for the longest time, affirmative action has been upheld, abortion laws have been set aside, and gun laws have been ignored. And I think going forward, you'll see abortion laws upheld, affirmative action policies declared unconstitutional, and gun policies halted. I think those are the three areas we'll see the most change. And there'll be some sort of mundane stuff with corporate law, which I'm not an expert in. You'll see stuff with antitrust. You'll see some other areas where the sort of progressive side will just not have 5 votes. Bostock, I think, was an exception because it had this unique textual argument. But, Bergefell was 5-4. And, if a Bergefell had been decided by this court, I don't think it would have been 5-4 that way. What other questions you have?
So, Professor, there's a case that was pending in Indiana where the AG, they just got a decision from their panel and they're bringing back up Bergefell and the recognition of second parent birth certificates, which I would have thought was a twice decided decision, and yet they're still pushing that. Do you see any traction?
Oh God, I know the case. I'm blanking on the specific facts. I don't want to tell you the wrong thing. I know the case. I know the case. I'm just blanking on the facts. I'm sorry, but I'm just googling it now.
Henderson's the name of the case. And,
just if you give me 20.
Indiana AG was trying to deny listing the second parent on a birth certificate for adopted children, I believe, which is precisely what we would issue in Pavon. So it looks like it's people who are doing the same thing.
How did the AG distinguish Ravon or say it's not relevant? I actually haven't looked at this case. I'm not sure.
I haven't delved deeply into it yet myself. I just thought it was interesting that the Seventh Circuit had sat on the opinion for.
Oh, that's right. They sat on forever.
And waited until there's a new court to release it. That's what raised the red flag to me.
Yeah, the Seventh Circuit had a couple cases like that. They sat on some cases for years. And I don't know you can say they were waiting for a new court because who the hell knew when Justice Ginsburg would pass away, right? It's hard to know in advance what's going to happen. But
they got a new court, and
yeah.
then the action happened. So.
Yeah. I got to take a look at this case. I'm sorry, so I'm not familiar with it, and I'd like to speak out of turn. But thanks for the question. I don't know everything. I try.
Okay, well, I'm going to ask the question probably fairly incoherently, but I'm going to take us all the way back to Masterpiece Cake Shop because so one of the things that I always struggle with is the distinction between it being an anti-discrimination, saying that you can't discriminate against somebody that comes into your shop and wants to buy a cake. But what I struggle with is the part of that that's that everybody always thinks about, which is if you have a private business, you have the right to be an asshole and discriminate against anybody that you want to. And so I think that's where I always kind of get lost in the case thing, is that I absolutely agree that we shouldn't discriminate against anyone, but am I just missing a private versus governmental connection or something?
Well, unfortunately, when you have a business, you don't have the right to be an asshole. It's just one of these facts of life. For a very long time, so-called common carriers, which you might remember from law schools, like a hotel or a restaurant, had a duty to take all comers. That if you showed up and you paid the fee, you got the service. If you pay the fee for a room and board, you get the room and board. That sort of understanding was expanded significantly in the 20th century with various discrimination laws, which weren't limited to common carriers. They applied to all manner of businesses, grocery stores and restaurants and, really anywhere a hardware store, whatever you want to buy. Those laws were also expanded to employment, that you couldn't simply hire, fire, or discriminate on someone based on various protected characteristics. The cake shop case is a little bit different because you're not asking for a product that's necessarily made off the shelf. You're asking for the creation of a custom good. And the facts in Masterpiece are very messy, and that might not be the best vehicle, but there are other cases involving florists, other cases involving photography, right? Imagine hiring someone to photograph your wedding. That's not an off-the-shelf product. They're coming to your wedding, they're attending, they're doing lots of things, they're using creativity. So the question is whether the First Amendment free speech clause imposes a limit on the ability of the state to make you engage in some sort of expressive conduct. Now that's the issue. That's not the basis on which Masterpiece Cake Shop was decided. I actually visited the shop. I was in Denver, and I just went for a trip. It was closed at the day, unfortunately, but I took a trip out there. You can go visit the bakery in Denver. The issue there was actually one of religious freedom, and the court completely punted. This is where I'm saying the court will become more conservative. There were not 5 votes to say that the First Amendment was violated, but there were 5 votes to say that in this specific case, there was evidence that the government was hostile towards Christians, and the evidence was pretty thin. But the court said, look, there's some evidence that the Colorado government was hostile towards Christians, therefore this is unconstitutional targeting, and the free exercise clause has been violated. It was a complete punt. So the Masterpiece Cake Shop case wasn't even about free speech, it was about free religion, which is, again, not all what you would think it's about. This is why, with Justice Kennedy gone, these cases start coming out the other way.
And I think that maybe was where I was having trouble forming my question, was because when you were talking about it being backwards on that Obergefell coming before
Bostock.
The new one. Thank you,
yeah.
Bostock. To me, those 3 all seem so interrelated, because I'm like, how I think I get confused on the difference between First Amendment versus the religious freedom argument. And is there a way that we can kind of better kind of frame that argument so we understand it, so we can explain it to other people?
Well, I'll tell you, there was a case called Elaine's Photography in 2013 or 14 involving a New Mexico photographer. And the Supreme Court denied review It involved a photographer who didn't want to photograph a gay wedding, and the court turned it away. So the court's been kicking these cans for many years. Just much of the court's business is just procrastination. I guess all lawyers procrastinate, but especially on the Supreme Court. Students do it as well. They'll do. They're all studying for my final right now. They should be doing something else, or they should be studying. And the court just keeps kicking the can down the road. Your question is a good one. I can teach an entire semester on those 3 questions, but understanding the relationship between free exercise, freedom of religion, and the sort of equal access is very tough, right? Whenever you create an exemption for people based on their religion or speech, you are invariably not treating someone equally, right? That's the trade-off, right? If you treat everyone equally, then people will have their free speech rights infringed, or they'll have their free exercise rights infringed. If you carve out exemptions for people based on their religion or their speech, then certain people may not get their services provided. Generally, the First Amendment trumps any statute, right? The free speech clause and the free exercise clause trumps any statute. But then the question becomes, what is free speech? Does free speech mean you don't have to make a cake? Does it mean you don't have to sell a cupcake off the shelf? Does it mean you don't have to sell a bouquet of flowers off the shelf? Does it mean you don't have to go to a wedding and take photographs for 2 hours of a couple? Whatever it happens to be. Does it mean you have to counsel gay couples who want to adopt foster children, right? There are a lot of very fine lines that are hard to draw, and my experience is the court just doesn't want to draw them, and they sort of punt and they find ways around it. They say, you guys deal with this, it's not my problem.
If you ever get permission to teach that class, please invite me, because that is the biggest confusion when I try to talk to people, and I'm like, well, I kind of get it, but I kind of don't.
Well,
and then I just confuse myself.
I am teaching the First Amendment this spring. Christiana will give you my email. You're welcome to sit in my Zoom classes anytime. By the way, all my lectures are on YouTube, so you can watch them on YouTube anytime. But it's a public service, but I'll be doing some of these cases this spring.
Thank you.
My pleasure.
It was always my understanding too with Masterpiece Cake Shop that it was about indentured servitude, and that might not be correct. But I mean, I talked to Jonathan Chigaris about it a little bit, and that it was sort of like you could sell a cake that was already pre-made, but to force somebody to have to make a cake because they were a private, not like a big Walmart type place, because they were a smaller place, they got the right to refuse service. So that was kind of my understanding of it, but that might not be correct.
It's close. The facts in Masterpiece were tricky because they did have cupcakes off the shelves that were ready for sale. So I don't want to focus much on the facts in that case, but in general, let's use photography as a better example. Because in photography, there's no photo album off the shelf, right? You have to go to the wedding, you have to photograph it, you have to arrange, okay, you stand here, you got to put the lighting, right? Then you have to sort of, edit the fixtures and Photoshop it and sort of, build a montage, I don't know, do all the wedding stuff, right? That is, in my mind, speech. You're engaging in expressive conduct, right? You're making an artistic book. Generally, the government can't make you do stuff. They can't make you engage in expressive activity. There was a famous case where there was a person who lived in New Hampshire. And in New Hampshire, the license plate said, live free or die state, right? That's their motto, live free or die. And he didn't agree with that. And he wanted to put a piece of tape over his license plate because he didn't agree with that slogan. And the state said, no, you can't do that. And the Supreme Court said, yeah, you can cover it up, right? You can't force someone to endorse your message of live free or die, right? So you can't compel people to engage in speech, that you have to carry a certain message. But that gets messier when you have a business that provides a service to the public and they don't want to provide that service to certain people. So the free speech issue and the cake and the bakery and the photography cases are very hard. They're very hard. And the court just did not want to touch it, and they're hoping it goes away. Because look, frankly, let's be frank here. The number of bakeries that will not provide a cake for a gay wedding is really small. I can probably count them on 2 hands, right? If you look nationwide, how many bakers say, you know what, I will not take a paying customer because they're gay, you have to go out of your way to find these. And the bakery in Denver, couples went out of the way to target them. Right now, they're asking to make cakes about transgender birthdays. They're targeting this guy to try and get him in trouble, and I'm not a fan of that. And you can like him or not, but there are a million bakeries that will give you a cake, right? It's hard to find not to. So this is a problem I think will just vanish. Just the number of service providers who have these objections will just dwindle, not to zero, but close to zero. This is not like Jim Crow where people are being denied access to lunch counters across states. I think we have to just get a grip on what we're dealing with here. This problem I think will just fade. And I think that's what the Supreme Court's doing. They're just kicking the can down the road, hoping it goes away. They never actually decide it. And like, okay, just leave us alone. We don't want to decide this hard issue. And that's my sense. And, the marriage issue I think has I mean, you know better than I do, but I think the number of bakeries that will refuse a cake for a gay wedding has to be very small. I think that's a good thing. I think things will move on.
Deborah, if you listen to the oral argument in the Masterpiece case, you'll hear that the justices were struggling with the very questions that you were raising, which are when does public accommodation type activity become expressive conduct? And where do they draw the line, or can they draw a line? And in my opinion, that's one of the reasons why they didn't answer the case they wanted to process. And I don't know about the story about targeting the particular cake dealer, but if you looked at the record, they had looked hard to find a process issue to complain about.
Yeah, it was a very unsatisfying ruling for everyone. It was a complete punt. It was not at all how I expected the case to turn out. And I think that's, again, Justice Kennedy did not want to decide it.
Yeah, I think it was more than a punt. I think it was a dodge.
I like that dodge, yeah.
It really was. I mean, what I remember, and I may not be remembering this correctly, but there was even an offer, I think, or maybe this was an analogy, that they give the customers all of the ingredients and supplies to make the cake, but they're not going to use their artistic ability to assemble the cake. And so that's how I think they narrowed it down to this is not about not selling them a cake. This is not about not even giving them all of the ingredients and supplies to make the cake. This is about my artistic expression. And they even talked about, well, what if a group of white supremacists came into your cake shop and wanted you to create a Nazi cake? Yeah. How would you feel about that?
Yeah. And
I think that those examples and analogies were helpful to the court in making their decision the way that they did, although I'm very concerned now about the balancing that we're doing between religious liberties, quote, and businesses who willingly enter the stream of commerce and basically sign a social contract with the rest of us that they're going to abide by all the same rules that every other business is going to abide by. I don't know that that's religious liberty there, because you've entered freely into the stream of commerce knowing the rules. So, I wonder how much farther this can be taken by someone who wants to test the Supreme Court on how far they're willing to take religious liberty over individual rights of people. And I'm going to sit back and watch and see how this plays out, because I think that that's going to start to come up more and more often. I don't want to do this or I don't want to do that, even though I've opened a business and I have a public accommodation, because doing this or that is going to infringe on my religious liberty. And I don't think that the court, even as conservative as it's becoming, is going to take it to a gross exaggeration. But I think that we're going to see a lot more religious liberties coming in to help protect, if you can say that, people from engaging in certain activities that they just feel is, I want to exercise my bias and prejudice instead, and I'm going to hide behind religious liberty to do it.
Well, I quite very much disagree with you on this one, and I don't use scare quotes from religious liberty. Something I put a lot of my effort in, but maybe for another time we can debate that. What else? Nope. All right, we are at just the top of the hour. I think we're right at 6.
I want to thank you for coming in and talking to us, and I would love to have you come back, and I will definitely be looking at some of your classes, because
I'd be happy
like
to.
I said, I did not get con law back when I was starting out, and I didn't get anything. And it's interesting to me to have come this far in my career and then be able to have these conversations, because there's a lot of things that like I felt like I understood, and then these cases come up, and I'm like, wait, now I'm confused again. And so I really appreciate you coming in and kind of, even though this was just a kind of a high level overview, I'm like, oh man, some light bulbs went on. So thank you so much.
My pleasure. Always happy to talk.
And I think we're going to hold Christiana to that, giving us your YouTube channel and letting us know when you are doing the
I will. You know what?
That sounds fascinating.
I'll put my link to my channel in the chat, which you can all have right here.
Okay, cool.
I can't. David has my thing locked down. Okay, I can't apparently put it in the chat.
That's weird. I didn't do anything.
I can only send you messages because I'm not the host. But anyway, I'm sure Christiana can send it around later. Yep, all my lectures are on YouTube, and you can watch them anytime you want.
Perfect. And I want to thank everybody, all of our members and guests for joining us tonight. We have a good crowd. I was trying to scroll through. Evidently, David can put everybody on the Brady Bunch thing, but I can only see a couple of you. So the people I can't see, hi, happy holidays and all of that. Thanks for being here. Anything else anyone wants to talk about before we let everyone go? Especially Josh, we're not letting you go yet. No.
It's okay.
Is there a way that we can do CLE? Is this a CLE? Is this for CLE?
It is. It is approved. And all you need to do, you can self-report, or you can send me an email directly with your bar number, and I can go in and add the attendance onto the approved CLE. They've made it all online now, so it's super easy. It won't take me more than 5 minutes, so feel free. If you don't want to mess with that, I'll take care of it for you.
Okay. Is there a CLE number that we can use? Or?
Yes. Give me 1 second. Y'all talk amongst yourselves. I'll pull it up, and then I'll give everybody the number.
Okay, but I do need to get going, so thank you all so much. Have a wonderful evening, and have a good night. Thank you.
It was awesome.
Happy Hanukkah.
Thank you.